as total 7 crores 82 lakhs 83,328. And now after all the adjustments, let me kindly see on the right side bottom, amount kept in abeyance. It's 4 crore 56 lakhs 64,812.
This is a demand kept in abeyance?
So let's say two parts. One is the demand. Other is the abeyance which I'm supposed to get as a refund, which they're keeping as abeyance.
This amount of 4 crore 56 lakhs
is kept as abeyance.
Is your entitlement?
It is my entitlement, which I was supposed to get.
This refund is kept in abeyance.
Refund is, I'm so grateful.
Okay. One more thing. This figure, arrear carried forward.
Malo.
This arrear is on what account?
This is the precise question. So there's a big question mark in my humble submission as to, in fact, that is the subsequently I'll show the affidavits your lordship had directed to be filed. So it's very unclear what these arrears are.
No details.
No details.
This bill is dated 9/1/2020.
2020.
Then what happened to this bill?
Well, this is what I had challenged.
The total demand is 8456.
845,60635.
Alright. Then this is prayer A.
Prayer A.
Then prayer
Just
B.
go back to the prayer B. Prayer B, my lords, is, and for issuance of appropriate writ order direction from this honorable court, for issuance of show cause to the respondents, asking them under which provision order direction amount of rupees 1 crore 60 lakhs 51,800 was kept in abeyance and bill dated 9/8/2008. This is Annexure 3 months.
Page 66.
Page 66.
Can you explain this bill also?
Can you see here again? What they've done is the total demand is on the right side bottom 2 crore 26 lakhs 24,202. On the bottom, my lordship, we see the last line kept in abeyance. By hand, it is written.
What is this figure? It is not legible.
It's 1 crore 60,000.
60 lakhs.
1 crore 60 lakhs 51,800.
Okay.
So again, this is an amount which is kept in abeyance. Again, my submission is eventually all this merges into the final bill, which will make things clearer.
And this is dated
9/8/2008.
No, this is 9/8/2008. Okay. Then please proceed further.
Kindly come back to page 4 towards the end I had read. Abeyance dated, bill dated 9/8/2008, page 5 over the bill. When the Court of Vidyut Ubhokta Shikayat Nivaran Forum, Ranchi, in its judgment dated 25/9/2007, passed in case number 18 of 2007, had directed to issue the monthly bills on the basis of actual KVA recorded in the matter, and further to adjust the excess money realized from the petitioner in the subsequent bills with interest. And for issuance of appropriate writ order direction from this honorable court, quashing the letter number 1380 dated 16/6/2021, Annexure 15, issued by Electrical and Executive Engineer Jamshedpur, respond number 4, whereby and whereunder a notice purportedly under section 56-47 of Electricity Act 2003, whereby a demand of 8 crore 29 lakhs 60,071 has been made, and in failure of the payment thereof, supply of electricity shall be disconnected.
This is Annexure 15.
This is Annexure 15.
One more question. This kept in abeyance figure is on account of demand or refund? Refund.
Refund. There were two separate refunds. I will indicate my lords.
Because kept in abeyance is not qualified by refund or
It is
demand.
not, my lords. Eventually they admit in the sub affidavit.
Alright. Now Annexure 15.
My lords. Page 118.
118. Yes.
This is a notice of 16th of June 2021 on the right side on top. Subject 15 days notice. Sir, this notice is being issued to you in accordance with the HT agreement, subsection 1 of section 56, section 47 of the City Act 2003. You are requested to pay the following dues within a period of 15 days from the date of issue of this notice, failing which your service line will be disconnected. Now, the amount noted is 8 crore 29 lakhs 60,071.
Then again, this refund is kept
On the right,
abeyance.
Malus, I am so grateful. Excluding rupees 4 crore 56 lakh 54,812 only as kept in abeyance. And then I am required to
So net demand would be around
3 crore 72 lakhs 3.72 lakhs.
mentioned in the bottom.
My loss by hand. Well, this is the third
Okay.
document.
Then you have one more.
And then minus one more. Should we kindly see page 6. This actually is the final bill which is coming during the pendency of the writ petition. For issuance of an appropriate writ order direction from this Honorable Court for quashing the letter number 1000 dated 26/4/2023 along with provisional final bill whereby the respondents have demanded rupees 7 crore 49 lakhs 27,967 being the net amount payable by the petitioner as illegal, arbitrary, without jurisdiction, as contained in annexure. This matters would be annexure 16.
This document is not referring to any amount kept in abeyance.
It does, my lord. I will show. This is the net figure they have indicated, but this is, in my submission, more interesting. Kindly see annexure 16 at page 119.
Yes, I'm there.
119 is the letter, 120 is the bill. This is the final bill as of now. Kindly see on the top left side, third line, issue date 26 April 2023, bill for revised provisional final bill. In the figures,
Date of disconnection.
date of disconnection is provided by us 1498.
Where is it?
Kindly see in
Date
between.
of, this is date of connection. Date of
Connection, I'm
disconnection.
sorry. Well, date of disconnection was minus 15 days after the notice, which is sometime in July 2021.
Disconnection. Okay, that initial notice.
My lords, the third document, that was of disconnection notice was of June 2021, my lords, 16th June,
Disconnection is July
July 2021.
1. Fair enough. That's right.
Now, my lords, in this bill at page 120,
Yes.
kindly see in between which says provisional final bill already served. Now the figure is 9 crore 36 lakhs 79,135. Again a completely different figure. Thereafter they have said less excess unit charged for the period June 2011 to August 2011. They have reduced 39 lakhs 85,912. Then they have further reduced the difference of contract demand and actual KVA with DPS for the period August 2009 to April 2010. This comes to 1 crore 47 lakhs 65,256. Deducting these two amounts, the claim is 7 crores 49 lakhs 27,967. Now, my lords, may I invite your lordship's kind attention to the remarks at the bottom, just below the remarks. Kindly see amount kept in abeyance.
There are 2-3 more. Provisional bill, provisional final bill
Yes,
dated
provisional
1
final bill rupees 1 crore 21 lakhs 6,965 served by this office letter number 160 dated 6/5/2011 against the theft of energy and FIR dated 4/5/2011. A sum of rupees 60 lakh 50,000 only paid on 29/8/2015 as per the Honorable High Court order dated 4/8/2015 in IN number 3675 of 2015 with LPA number 350 of 2015 and LPS pending before Honorable High Court. This is
continues
independent.
to be pending.
This is continues to be pending. This is independent and not connected with the present petition.
That is on theft. इसका जरा status बताइए. LPA 350 or 50. Yes, continue please.
My lords, we now see amount kept in abeyances. difference of KVA rupees 3 crore 21 lakh 29,513 is still kept pending before the Honorable Supreme Court of India, which will be payable by the company if the decision will be in favor of JBBNL. So this is a matter pending before the Supreme Court that concerns the second connected writ petition, but the matter is pending there. Second, my lords.
And this demand has been set aside
No.
by the forum.
By the forum. Presently, it is pending. As of now, I have succeeded.
Okay. As of now, you have an order in your favor.
I have an order in my favor.
This demand does not survive against you as of now.
As of now.
But that is subject matter of consideration before the Supreme Court, and if they succeed, then under such circumstances.
No, the payment has already been made. In case I succeed from Supreme Court, I'll get that refund.
Who has gone in appeal?
They have gone in appeal. I had succeeded in the High Court, but the payment was made much before that.
Okay.
Before the quashing of the debt.
Alright.
Whereas then B, last, difference due to reduction of contract demand from 51 kVA to 2700 kVA amounting to rupees 2 crore 58 lakh 42,428. But so far as this amount is concerned, I had succeeded. They had not challenged it. And this is something which I am entitled to as a refund.
This is order passed by which court where you have succeeded?
Well, this is passed by the forum.
Forum.
Consumer forum.
Not under challenge in
Not
any
under challenge,
proceedings?
admittedly, it has come even in the affidavit. It was a challenge before ombudsman, upheld by ombudsman finally, never challenged thereafter.
What was the case of the ombudsman? Case number?
Document words.
You just give me the
I will
case
just
number.
give, I have the Bhokta details. I'll give the details. Let me just.
No problem. All right, this is done.
But in view of this position, may I now invite your Lordship's order of 13th October, where I had made my submissions and there was specific direction to clarify on all these figures. That order is of 13th October.
Just pause here for a moment. Difference of KVA is still pending before the Honorable Supreme Court of India,
Yes.
which will be payable by the company.
No,
Company is
really-
indicating what?
No, it really means that ultimately will be refunded by them to me. Probably that's
It says which will be payable by the company if the decision will be in favor of JBBA.
That's what they have indicated, but as I said in the affidavit, they have clarified all that.
Okay.
That is why it is said amount kept in abeyance.
Abeyance are of two kinds.
Could be of both sides. I
Demand
understand.
kept in abeyance and refund kept
Refund
in
kept in
abeyance.
abeyance.
Okay. Yes, now you argue.
What's that order of ombudsman your Lordship had wanted? That is at page 101.
Just give the case number. I just need the case number because while dictating, I need those case numbers.
Case number 03
Of
of 2015.
you refer to the page number, no? What is that page number?
116.
No, that ombudsman order.
116.
116. 116 is the bill, the order of ombudsman. No, where is the order of the ombudsman? I'll just mark it for myself.
Let me kindly see page number 40. Annexure 2, page 40.
That's
This is an appeal filed by JSEB against the order of Vidyut Upbhokta.
Name of your company is KYS
KYS
Manufacturers.
Manufacturers.
Okay.
May I invite Lordship's attention to the order of 13th October 2023.
Yes. Yes.
Paragraph 3. It has been submitted by the Direct Counsel for Petitioner that an amount of rupees 7 crores, must have been figure missing, 92 lakhs, has been shown in the bill which has no basis at all. Even from the counter affidavit, it is not clear as to on what account this bill has been raised. Paragraph 4. It is submitted that an amount of rupees 2.58 crores has been shown as kept in abeyance, which is refundable to the petitioner with interest, as it has not been refunded since 2011. It is submitted that another amount refundable to the petitioner has been shown in the bill, which is rupees 3.21 crores, which has been kept in abeyance. Paragraph 5. The Learned Counsel further submits that unit of petitioner has an induction furnace that has gone out of production since 2021 on account of disconnection of electricity, and the petitioner is willing to start the unit but is unable to start due to disconnection of electricity. 6 months. Learned Counsel appearing on behalf of respondents has submitted that a supplementary affidavit is required to be filed, clearly stating as to under which head the amount of rupees 7.49 crores has been shown in the bill on page 120 of the writ petition, and to bring on record if there is any previous bill has been raised in connection with the amount. The Learned Counsel for the respondents is directed to clarify that position with regard to the aforesaid amounts shown as kept in abeyance in the supplementary affidavit to be filed. So 2 parts my lords clearly are directed. One was clarification of 7.49 crores. Second is the 2 abeyance. Against this, my lords, the supplementary affidavit was filed on 8th of November 2023. I would not trouble your lordship in going through that, because then we made a statement that it is not in terms of the earlier order, and therefore a fresh affidavit was filed by them. So effectively 8/11/2023.
Thereafter, they filed another affidavit.
Another affidavit. So may I just read the first December order, where a statement was made on her behalf that the earlier affidavit is not in terms of the order.
Yes, I am aware.
Lordship.
I remember that. So they
Only paragraph 3 I would like
we
to
will
read.
not exclude this particular affidavit because they may place reliance on that. But we'll read both the affidavits.
My lords. Let us then place the affidavit of 8th of November.
Yes, please.
My lords, may kindly see paragraph 5, page 3, paragraph 5.
Yes.
That the instant writ application has been filed for quashing the bill dated 9/11/2020 towards bill for the month of October 2020, wherein an amount of rupees 4.56 crores is kept in abeyance, and issuance of show cause to the respondents asking them under which provision an amount of rupees 1.60 crores was kept in abeyance in bill dated 9/8/2008, when the court of Vidyut Upbhokta Shikayat Nivaran Forum Ranchi, by its judgment dated 25/9/2007, passed in case number 18 of 2007, had directed to issue the monthly bills on the basis of actual KVA recorded, and further to adjust the excess money realized from the petitioner in the subsequent bills with interest. Further, a prayer has been made for quashing the letter number so and so issued by Triple Executive Engineer, and notice issued under so and so. That entire paragraph of the prayer. Now, kindly see paragraph 7, where the explanation starts. that the amount of rupees 4.56 crores was kept in abeyance as the case of actual KVA in the matter of HTSS consumer is at present under adjudication before Honorable Supreme Court of India in JBBNL versus Lord Balaji Steel Manufacturing Private Limited and others, bearing SLP number so and so. The Supreme Court of the monthly bill of HTSS consumers after January 2004 was continued on the basis of 100% contract demand. Messrs. KYS went to VUSNF and USNF passed judgment dated 25/9/2007, in which the impugned bill issued to petitioner for the period 1/1/2004 and onwards, where KVA charges had been raised on the basis of 100% contract demand, was quashed, and the respondents were directed to issue monthly energy bill on the basis of actual KVA recorded in each month. An appeal was filed by JBBNL before the ombudsman, and the ombudsman upheld the decision of USNF by judgment dated 28/2/2008. Due to no guidance provided from board, the amount of rupees 1,60,51,800 being the difference of billed KVA and actual KVA from 1 April 2004 to March 2008 was kept in abeyance as per approval of General Manager. Since the board had filed appeal in High Court and the matter was under dispute, thus total of rupees 3,22,29,513 was put in abeyance and continued till November 2016.
This 160 is not matching with 322.
It's actually, in my submission, they have actually mixed two issues in this. There are two figures of abeyance. One is under challenge, it travelled up till Supreme Court, which is pending, to which we know
You
where.
have said that.
Yes. The other figure actually they have been slightly mixed up because it went to the forum, I succeeded, they went to ombudsman, they lost, and the matter stands as that it is. Somehow, after writing that, then they again wrote about the board filed appeal, which is in terms of the other matter.
This 322 is relating to SLP? This
SLP
is
matter.
SLP matter.
Kindly see para 8. That further in case 3 of 2015, BUSNF has passed order dated 12/11/2016, directing the respondent to prepare fresh bill on the basis of reduced contract demand, considering the date of approval for reduction of load as on 7/4/2011. This is the figure and this is that bill which they are to refund anyway, which is nowhere under challenge.
This is another case.
The second amount.
This relates to which period?
This
Because there is already an order passed in this
the earlier appeal.
earlier
Yes.
25th of September 2007. KVA charges.
KV charges.
That is one case.
That is one case.
This is the second
This
case.
is reduction of contract demand. This is the figure where I had challenged before forum, succeeded. They went to ombudsman, lost, and that has attained finality. I will show. As I said, that's the reason a fresh affidavit was required to be filed.
That's true.
Because of the confusion which was apparent here.
Then
Kindly see para 9. That in the light of order passed by BUSNF electricity bill of KYS, recasted from 14/2011 on the basis of reduced contract demand 2900 kVA instead of served bill of contract demand 5100 kVA, and the difference of already served bill up to November 2016 and recasted bill amount rupees 2,58,42,428 was kept in abeyance, as total kept in abeyance amount became rupees 5.79 crores. That is in two parts. One is 4.56 crores, other is 1.23 crores. And a request letter was written to law officer for filing of appeal against the order of USNF. At the time of online bill generation by SRIT, the amount was shown as rupees 4.56 crores. In SRIT generated bill, the amount of rupees so and so was shown only as one part, which should have been. In my submission, my lords, these figures
are totally mismatched.
that was precisely what we had submitted before your lordship, and that's why a fresh affidavit. This was clearly didn't really connect well.
They will have to explain their
They will have to
It may be that we are not
My
able
lords,
to get
my
it
lords,
properly.
got you. In para 10, my lord, subsequently an appeal was filed before Honorable Ombudsman.
So this is the long and short of the matter.
This is the long and short of the matter. Now may I just invite your lordship's kind attention to the order of 1st of December 2023, where we had indicated just one paragraph. It's a short order.
1st December 23.
My lord.
Yes. That's right.
Paragraph 3. Paragraph 2. Upon this, learned counsel for respondents has submitted that within a period of 2 weeks, he shall file the required affidavit. 3. My lords. Let the required supplementary counter affidavit be filed on behalf of the respondents, and in case the required affidavit is not filed in terms of the order dated 13th October 2023, no further time will be granted and the case will be decided based on the pleadings and materials available on record.
That's right.
So this matter, led them to file a supplementary affidavit again on 8th of January 2024, which is the last one on there.
Let us see that. Where they give a chart.
Where they give a chart. Paragraph 5, page 4, paragraph 5, towards the end where they say the details breakup of the bill is as below. Why not have the table?
Yes.
Over the page 5. Now kindly see seal number 1. This is nothing but a copy paste of the bill itself, nothing beyond. Net assessment from August 2009 to July 21, including assessment of so and so in July 21, 2 crore 21 lakhs 15,162. 2. Current DPS 7 lakhs 55,290. Third, area energy charge 7 crores 4 lakhs 2,031. Arrears of electricity duty 4 lakhs 6,450. Then the DPS is adjusted, my lords, it's reduced. Amount then is again further reduced on certain accounts, and the net payable amount is 7 crore 49 lakhs. Now, what your lordship had also clearly given in the order was give supporting previous bills. This is the entire detailing they have given. We do not know which energy charge for which period it is given. DPS is against which arrears which was there. No detailing but for this table. So far as the justification of 7.49 crores is concerned, this is the only table which is provided in this last supplementary affidavit pursuant to lordship's orders. So this is my lord's one thing which they would have to explain to your lordship. This is first part. Now let's kindly see paragraph 6. Now these are the paragraphs with respect to the amount kept in abeyance. Paragraph 6. That apart from above, it is stated and submitted that principal amount of rupees 3 crore 21 lakh 29,513 is kept in abeyance on account of difference of the contract demand charged and actual KVA from August 2009 to April 2010, as the consumer is HTSS tariff and such matter is pending before Honorable Supreme Court of India, which will be payable by the consumer if the decision will be in favor of JVBNL.
Payable by the consumer.
Again, it says so, my lords, I understand, but then my instructions are the amount was already paid long time back, but that is something.
From where do I get this?
Well, that is a part of the second writ petition, and that is why I am not even troubling this part.
Okay. This you are not concerned.
I am not concerned. This is pending in the second writ petition, which should await the
They
decision.
will argue. They will argue. Let us see. At least from that writ petition, we can figure out
Lordship.
whether this amount has actually been paid or not paid, and they will have to answer, because if there are dues, if there is difficulty in refund,
My lord.
right? So according to you, this amount has been paid, which can be seen from the other writ petition.
My lord, it can.
Okay.
Now paragraph 7, my lord. That is further stated and submitted that an amount of rupees 2 crore 58 lakhs 42,428 is kept in abeyance on account of difference amount due to reduction of contract demand from 5100 kVA to 2700 kVA. And then paragraph 8, my lords, this supplementary affidavit is filed bona fide. That is all. These are the three paragraphs.
This is serial number, para number 6 is also on account of reduction of KVA.
Well, this is exactly
From the period from 8/2009 to 4/2010, and so far as serial number 7, paragraph number 7 is concerned, this is for subsequent period, or it is overlapping.
No, so far as this paragraph 7 is concerned,
Yes.
that is something which is with respect to that particular reduction of the contract demand.
See, this particular figure of 321.29
My lord.
is also relating to reduction of contract demand.
No, but 321 is slightly different issue. There the issue was whether the charges have to be on 100%, KBA charges have to be on 100% contract demand or on the actual demand.
That's right.
So that was an independent issue which is pending. The second part is about when I had reduced my contract
This
demand.
is on application for reduction, and that contract demand was reduced.
My lord.
When was it reduced?
I
And where
will-
is that averment that the contract demand was ultimately reduced to such and such amount from this to this?
So then may I invite your lordship's attention to page, then the orders
So
itself.
then only paragraph 6 and 7 will become will get segregated.
My lords. So may I
Otherwise,
just-
it will be a sequel.
So may I just invite your lordship's attention to the orders of JBU, DSNF and the ombudsman, which will make things clear.
No, there is no problem on that.
My lord.
There was a dispute as to whether you are to be billed on actual KVA
My lord.
or whether you have to be billed on 1000 or whatever,
My lord.
like the contract demand.
Lordship. 100%.
Then ultimately it was held that you are to be billed on actual KVA,
Yes.
right? And then the bills were to be revised
My lords.
and the amount was to be adjusted. That happened till a particular period.
But that has travelled to Supreme Court in pending.
That has travelled to Supreme Court and matter is
My-
pending. If there is a sequel to that,
My lords.
that for subsequent period also, this method of billing continued,
My lord.
and then you are still entitled to one
Lordship.
refund, then that will be a sequel to the judgment to be passed by the Honorable
My lords.
Supreme Court. We shall not touch it.
My lords.
There is another way to look at it, that there could be an order by which the contract demand has been reduced, maybe from 2,500 kVA to 1,000
My
kVA.
lord.
Then under such circumstances, the nature of dispute
My
with
lord.
regard to contract
My
demand
lord.
will itself change,
My lord.
and para number 6 will be totally segregated from para number 7.
I understand. Lordship. My submission is that is what the situation is. Because the reduction of demand is a completely independent issue. When once it has been reduced, then to that extent that the difference amount is what they could not have charged. Instead of charging 2,900, they charge at 5,100. So that was a different issue. But my actual demand could have been still lesser, even lesser than the 2,900.
That's
And therefore, that is the issue which is pending in Supreme Court. So these are two totally independent. Even it is not even their case that these are overlapping in any manner. So
So
far
we
as
need to understand, no? So I just want to know what is the date on which the amount, the contract demand was actually reduced.
My
Mr.
lord.
Agarwal will be in a better position to
So may I just-
tell you this.
That is mentioned in the
You just give me a date.
date also, just I'm giving. That is also date is July 2011 also.
July
And
2011.
the application was made by the consumer.
Okay. It was reduced from what to what?
From July to onwards, also. The
It was reduced to what?
5100 to 2900.
5,100 to 2,900.
It is 2700 mentioned in para number 7. It's 2700.
Maybe
It might not see it at the-
that appears to be typo.
2900.
2900.
All right.
Well, this is the entire supplementary affidavit which they have filed in my humble submission. Does not again reflect any detail whatsoever, especially of the 7 crores and or which they are demanding.
That's right.
The abeyance part, first part, Supreme Court pending, I am not touching. 2.58 crores is clearly which is outstanding since 2011. So even if I add up till interest today, my lords, it will cross even 8 crores. So in my humble submission, my lords, today is a situation where despite your lordship's orders,
Under which provision of law you are entitled to interest on this refund amount?
yes, so my lords,
There is a statutory provision or
statutory-
there is an order?
statutory. So may I just show the service code. Till 2020, it was at 1.75%,
Okay.
and after that, it is 1%.
This is being fixed by ombudsman from time to time, or it is
No,
fixed?
this is by in the regulations, electricity supply code regulations.
That's right, fixed by
By the
ombudsman,
JCRC, by the commission.
regulatory commission.
Regulatory commission. I'll just give a copy.
So 1.7% Interest only per month?
Per month, 1.75% per month. This will be from May 2011 to March 2020.
That will add up
It
to
will-
around
it is-
18%.
It is coming up to Malus almost 4.79 crores. And then after that, Malus, it was reduced to 1% per month, which almost comes to 93 lakhs. So if we add with the original admitted amount which they are supposed to refund with interest, it almost comes to 8.39 crores, 3 crores. Even if I presume for a moment, Malus, the 7.49 demand to which there is no details, still I'm supposed to pay whatever they have said. There is clearly a set-off of 8.3 crores till date. So there is no question on that basis that they should be allowed to disconnect my electricity.
So you say that your electricity should be restored
And-
without any further payment,
Not should.
and the same should be subject to whatever refund you are claiming before the Supreme Court by virtue of the judgment, which you say that this amount 3.21 is already paid.
No, so two of them are abeyance. One is pending Supreme Court, and the second writ petition. The
Pending
amount of,
Supreme Court, which is in abeyance,
Well-
is also something which you have already paid according to you.
according to me, I have already paid.
So,
yes.
so what is pending is the refund.
Refund the second figure of 2.58,
Yes.
which is
not
between-
under challenge at any
at all.
proceedings
Yes.
at all.
Yes.
So if this amount is refunded, which they are not doing,
My lords.
or adjusted,
My lord.
then only there is a question of any further payment.
So I have two submissions, my lords. One, anyway, my primary submission is that their claim of this 7.49 crores, anyway,
It's big.
they have not given any detail at all whatsoever.
That's it.
But as I say, even for arguments, I presume I'm supposed to pay. Then anyway, I have this set off which is there in terms of admitted amount with interest which comes to 8.4 crores. So therefore, the disconnection in my humble submission is something which is clearly arbitrary, which ought not to happen.
Now let's hear them on the breakup.
What should-
Yes, you are.
Well, basically there are two issues, my lord. Kindly have a look to my my lord, written submissions, my lord. My lord. Two issues are there, my lord. One is with respect to, my lord, actual KVA and the billed KVA. So there was an order of the ombudsman that the consumer has to be charged on the basis of actual KVA, although the bill was being charged on the basis of actual contract demand value, or 100% of the KVA or the actual contract demand value.
That's it.
So this
What
matter,
was the period involved in that? particular case?
that is the main dispute in question.
What was the period
Yes.
involved?
My lord, the period is, my lord, in 2004, my lord, new tariff came up, my lord.
Period item, and my question is very specific.
Yes,
What was the period involved in the order
from
passed by ombudsman?
2004 to 2010.
2004 to
2010.
2010.
Yes,
So therefore, with respect to your affidavit
my lord.
in paragraph number 6,
6.
it can be safely said that it is relating to the period 2004 to 2010.
2010, that is
But you
320.
have stated that it is from 2008, from 8 2009 to 4 2010.
My lord, why it is so, my lord? It was done in two parts.
Okay.
First, when the order came, my lord, it was done from 2004 to 2008. That came to 1 crore 60 lakh. And subsequently, they realized that they have to give benefit up to 2010, my lord, when the order was passed. Now, what they again calculated 1 crore 60 lakh 77,000. If you add both the amount,
From
then
your, please show it from your records.
yes, ma'am.
Please.
From records only, I will show, my lord.
You
If your lordship
show-
wants me to show from records, I will show.
I want to see from the records.
Yes.
I'm only concerned with the records.
Ma'am,
I don't
ma'am,
entertain
ma'am,
any
ma'am.
submission beyond records.
Yes, ma'am.
You know
I will
that.
not. I will not. My lord, I will be referring to my written submission, my lord.
Written submission has to be based on records. You show it
My
from
lord,
the
it
records.
is, my lord, whatever the statement we have given in our affidavit, my lord, that does not my lord, the details of the bill in which it was reduced, that was not given, my lord. They were
That was
supposed to
so
give,
many orders have been passed for that purpose.
my lord.
Then, so many orders.
So, my lord,
Because we do not want to non-suit you like this.
my lord,
Merely because they have raised a point, that does not mean that they will get the relief.
my lord, I have, my lord, even my officer is
Yes,
also
who is
here,
your
my lord.
officer?
Yes.
Call him here only. Yes, please come here.
And he is with the entire records also, my
What
lord.
is your qualification?
Electrical engineer.
Electrical engineer. You understand English? You have read the orders? Why didn't you comply it? हाँ बताइए कहाँ सबमिट किए हैं बताइए आपसे हिंदी इंग्लिश बंगला उर्दू पंजाबी जिसमें आपको समझ में आए आप बहस करिए लेकिन आप हमको जरा बताइए You will raise a bill of 7 crore without any foundational detail.
No, all the details.
If there is a bill of 7 crore,
Yes.
it must be backed by number of bills.
Yes, yes, correct.
That cannot be the solitary bill.
No.
Where are those bills?
I have enclosed, my lord.
Where is it?
My lord, in my written submission.
This is not done. Written submission is not a part
My
of
lord,
the record.
therefore, my lord,
Therefore
your
what?
lordship directed, I examined the entire records, my lord. Thereafter, my lord, I came to, my lord,
And Mr. Yadav, one thing.
my lord.
I've never seen a written submission filed on affidavit.
That is
Written
why.
submissions are
that
filed
is-
on affidavit.
my lord, that is why, because some documents that was not on record, and I wanted to put it in my.
That is a separate thing. You
my-
can file a supplementary counter affidavit to that effect. You file a written submission on affidavit.
That is why I suggested to file it on affidavit so that the court. may
Your
not-
suggestion.
my lord, it was
I
my
thought
suggestion.
that he would have suggested you
No,
to file on
I
affidavit.
suggested, my lord.
Under what provision, under what system you file written submissions on affidavit?
My lord, then I will permitted to withdraw that affidavit, my lord, because there are certain bills which was not enclosed in the counter affidavit, but we are for the purpose of submission only.
Okay,
we
let
have,
us see. Let us see what bills you are talking
Yes.
about. Let us see the breakup of the 7 crore first. No, first let me understand paragraph number 6 and 7.
उसी को समझाना है. हाँ. Page 11, if you lordship.
Written submission.
Page 11. Hello, this is bill dated 9/9/2008.
Yes.
Madam. Hello, the current bill, my lord, along with area, it was 2,39,44,614. Madam. Your lordship got it. 2,39,44,614.
From where do you get
is
this
the
arrear?
net amount payable, madam.
What is this arrear?
Madam?
2 crore arrear in 1998.
Yes, madam.
What is the breakup of this?
Madam, breakup is given above.
Yes.
ऊपर से देखा जाए
A grant add
energy
arrear.
consumption, maximum
आपका सब
demand.
चीज है.
हाँ.
आप यहाँ पे देखिए 2
हाँ.
करोड़ arrear.
हाँ, ये है रिबेट देने के बाद जो
हाँ.
इसमें 2,39,00,000 की तो है.
नो ये arrear में एक फिगर
ये
दिखा रहा है
हाँ.
2,006,7,889.
Yes, madam.
हमको तो पढ़ने भी नहीं आ रहा. What is this arrear?
ये जो है इसमें तो एक 60 माइनस किया. My lord, from this amount, 1 crore 60
You first
lakh.
tell us what is this arrear?
My lord, this is area is regarding पिछला from the previous bills.
Where is
It is
that?
coming now.
That is why, no.
Ma'am.
You need to know. You are picking up
Because-
an arrear. Then you have to
Ma'am.
tell us. You have to tell us the entire chart that for this month, you see, there would be one or the other month where there was no arrear, isn't it?
Madam, they have been always making short payment. Madam.
Okay.
That was carried forward as an arrear, madam. And on that
We
amount,
do
they
not
have
know.
also prepared a full chart. Madam.
Where is that chart? What is the date of their connection?
Date of connection is, my lord, इसमें दिया हुआ है
1498.
1498.
1498
तो 1498 से लेकर
मैडम
ये 2008 तक का only how many bills? 10 bills. Where is that chart? And where is that calculation? And under what head it is in arrear?
area is towards the कौन सा bill है ये? Current bill है ये?
कुछ नहीं आप लोगों को पता.
Area was
ऐसे आप नहीं परेशान कर सकते किसी को.
मतलब एक थोड़ा सा 5 मिनट समय दिया जाए.
हम तो 5 मिनट के आपको 5 घंटा समय देने के लिए तैयार है. 7 करोड़ का बिल तो हमको समझ ही नहीं आ रहा.
बस 2009 से
और इंडस्ट्री को बंद करके छोड़ दिए. डिस्कनेक्शन नोटिस.
from 2009, August 2009 to 2021, we have calculated the entire arrears from the bills also. The bill.
कुछ नहीं, हम आपको एक कहानी हम आपको नहीं सुनने वाले.
एक जरा सुन लीजिए. जोड़ा. I got the point. ये जो 2 करोड़ और ये जो एरिया जो दिखा रहे होंगे, this is added in the right hand column that is from the total bill.
Yes.
Now the current bill as well as the area that comes to 2 crore 39 lakhs. 2 crore 39 lakhs. Now we calculated the KVA charges on actual consumption balance. So from 2004 to 2008, that came to 1 crore 60 lakh, and we deducted this amount from their current bill, including area. Area का भी जोड़ने के बाद 1 crore 60 लाख घटाए, तो it comes to 79 lakh 34,000. And ये फिर क्या जोड़े हैं? 41,000. This is the corrected amount, and the total amount due is 78 lakh. This is in 2008, madam. We have given effect to the KVA difference. Madam.
They are fighting this since 2008.
Yes, madam. I will come to that. Madam. I will come to that. उसके बाद देखा जाए.
नहीं आपको नहीं, शाम को तो अभी इसी बिल पे मेरा दिमाग अटका हुआ. आप बताइए, एक्सप्लेन दिस बिल.
क्या पता
ये
है?
2 crore 67,000 lakhs ये क्या है? What is this?
2 crore.
Arrear.
ये arrear है.
From on what account?
On account of their current bill, they have not.
So therefore, I
And
want to know
why
from you.
why they were not paying? Why they were not paying? Because their dispute was going on regarding KVA charges. Therefore, they.
You just now said that in the KVA charges that the tariff came into force only from 2004. So there cannot be any dispute prior to 2004.
Let me clarify. Their connection is of 1998, madam.
Yes.
Now, जो पुराना टैरिफ था जो 1993 का HTSS के लिए डिफरेंट टैरिफ था.
That's right.
और वो टैरिफ के हिसाब से they were being charged. Now 2004 में जो नया टैरिफ आया, they claim that 2004 tariff will apply where the actual consumption, actual contract demand, consumption of this actual contract demand has to be charged, and not on the basis of earlier tariff. The board was fighting on that basis that since there was an agreement between the parties that will continue, and therefore the board filed appeal also, my lord, as against which the writ is pending, and in another matter Lord Balaji, my lord, Supreme Court matter is pending regarding that issue. So the KVA charges, 100% KVA charges was being charged since the inception of 1998. It is not that in 2004 to 2008, but we gave the effect from 2004 because there was no dispute prior to 2004. The dispute came in 2004 and the court has,
If there was no dispute prior to 2004,
there
then
was
there
no
was
question.
no occasion of non-payment of bill. If there was no dispute prior to 2004,
ये तो हुजूर ये तो 2008
आप
में नाम
हमको
इफेक्ट दे रहे
हमको
हैं.
ombudsman का ऑर्डर चाहे फोरम के ऑर्डर से दिखाइए कि डिस्प्यूटेड बिल किस पीरियड का है, दिखाइए,
दिखा देते हैं.
उसी से पता चल जाएगा.
Yes.
हाँ बताइए.
टू 2006 में ये
Page 54 Lordship. Page 54.
page 53 it starts.
Page
The
54.
petitioner was granted electrical connection for 2700 kVA for running induction furnace, which was Nujaj on so and so. And on 3/2006, after sanction of additional loan, the total load of the petitioner became 5100 kVA under HTSS category
2.2.
mode of 10.
Page 54, 2.2, para 2.
एक मिनट सर, लेट देम. आप एकदम नहीं डिस्टर्ब करिए. 10 लोग बोलते हैं तो चीज़ें क्लियर नहीं होती. उनसे पूछ रहे हैं तो आप बोलेंगे तो फिर आप ही से पूछेंगे. उनसे पूछना बंद कर दें. हाँ यस.
Effective from 1/1/2004, it is stated from 1/1/2004 and onwards, as per Tariff 2003, the petitioner is to be billed against maximum demand KVA charges per month as maximum demand recorded in that month and not on the basis of 100% of the contract demand. So this was the dispute. But the petitioner, even from 1/1/2004 and onwards, has been billed for 100% of the contract demand instead of actual recorded maximum demand in the meter. It has been further stated by the petitioner that after the enactment of Electricity Act 2003 and publication of new Tariff 2003, earlier tariff schedules of 24/9/1999 and 7/5/2001 issued by BSEB have been repealed, and the Jharkhand State Electricity Regulatory Commission has also declared by its earlier order dated 19/12/2005 these tariffs as not applicable documents with effect from 1/1/2004, and as such the action of the respondent is illegal, arbitrary, bad, and the petitioner is entitled for refund of the excess paid amount with suitable rates of interest as per law. That it is stated that now the prayer mallard, if it is page 55 mallard, the petitioner prayed for setting aside the energy bill issued by the respondent from January 2004 to April 2007.
That's right.
Yes, ma'am.
So your bill is of 1998, which was
No, 2008.
2008.
2008.
Okay. So this is
After because I have to give effect from January 2004
Yes.
to 2008.
Okay.
So twice this effect was given because the 100% TV charges continue to be charged till 2010.
Okay.
So 1 crore 60 lakh first and another, so it comes to 3 crore 21 lakh. Now from the current bill we have given effect of that amount, and whatever is the actual amount which was given effect, that is the amount which is kept in abeyance because the issue is pending before Supreme Court. If
Yes.
the board
Just-
wins that case, that we will be entitled to that that amount, my lord.
just a moment. This judgment was passed on 26/9/2007.
Yes, ma'am.
This ombudsman,
Yes.
this judgment,
Ah,
right? Now you come to your bill.
bill.
Back to the bill.
My lord. So
Just a moment. This is for this is dated 11/10/2008. No,
My lord,
no, this is dated 9/9/2008.
my lord, the order was
Now
passed
you
on.
say,
My lord,
that's right.
order was passed by ombudsman, my lord, dismissing our appeal on 20th February 2008.
Okay, all right, no problem. Now you tell us that after the order of the ombudsman, you were supposed to give them adjustment
Yes.
by
That-
way of refund,
Yes.
right? If they were to be refunded certain amount, then why this arrear would come? If they were entitled to some refund,
No, refund was not the issue. That is not the direction.
adjustment.
Adjustment.
Okay.
So
So if
adjustment has to be from the current arrears.
adjustment has to be from the current arrears.
Yes.
Okay.
Now, in 2008,
Hmm.
their current area shows the area of 2 crore 39 lakh. Current area
No.
shows
Current. So this is what I want to know. This
area
current
along with the
arrear.
current bill. Yes.
This current arrear of rupees 2 crore 67 and 2 whatever the figure is not relating to KVA. It cannot be. Because by virtue of the order passed by the ombudsman and the forum, you were supposed to refund the amount and adjust it against current bills. Then how this amount of arrear would come? Under which head this arrear is there? It is
Hello.
certainly not on account of KVA charges.
My lord, may I explain? Now, if your lordship will come to the same
You get
bill,
my question? Yes, Mr. Engineer, you got this question?
बताइए.
This particular figure cannot be on account of any KVA charges. This particular figure, दो ही charges होता है. Current consumption in terms of amperes, right? And the other is the KVA charges, fixed charges. This cannot be on account of KVA charges because by this time there was already an order of refund. Refund by way of adjustment. Yes, yes. Then this particular amount must be on account of energy charges. What is the breakup of this amount?
May I submit, my lord, what I have understood?
आप लोग को कुछ जाता नहीं, एक दो जीरो लगाते जाते जब जहाँ मन होता है.
नहीं, एक मिनट खाली समझा दें.
समझाइए, पहले खुद समझ लीजिए.
हम खुद जितना समझे उतना तो बता दें हुजूर को.
समझाइएगा तो आप जरूर.
हाँ, एक बार ये बिल देखा जाए हुजूर पेज 11.
हम उसी पे
उसी पे अटके, ठीक है. ये
इसके
ऊपर
आगे
में
हम
देखा
बढ़ ही
जाए ना
नहीं पा
हुजूर,
रहे.
बिल दो पार्ट में है. एक है एनर्जी कंजम्पशन का और एक है
एक
मैक्सिमम
एक
डिमांड.
आइटम देखते हैं. Energy consumption 2, the maximum demand 153, current charges, right? 2 plus 153. उसके बाद ये सारा फिगर आ गया, है ना? Then you have this this 4 crore, this much figure 405.
40,000.
No, उसके नीचे आइए ना, वो 40,000 भी हम लोग भूल जा रहे हैं. 405 आया फिगर, right? No problem. Okay?
ELCBMC.
You have this, you forget about rebate or whatever. Now you straight away come to this figure, 2,006,7,889.
This,
From where you get this?
this figure includes KVA charge, KVA billed on the basis of 100% of contract demand. And
How can this include KVA billed on the basis of 100% of KVA charges? Because by this time there was already an order to adjust this amount and give you the refund. Refund by way of adjustment.
नहीं, बाद में किया because they
में वो टैरिफ में था कि एक्चुअल कंजम्पशन
टैरिफ में तो था, ऑर्डर में नहीं था ना. आप अभी तक टैरिफ में अटके हुए हैं, ऑर्डर तक पहुंचिए.
होने के बाद में जब हम लोग अपील पे गए, इसके बाद इस अमाउंट को केप्ट इन अवेंट्स में रखा, कैलकुलेट करके जो हुआ जो एक्चुअल कंजम्पशन 100% जो डिफरेंस.
So according to you, this figure of 206 is on account of KVA charges on full contract demand.
ये दोनों एनर्जी के एंगल से भी है, कॉन्ट्रैक्ट भी है.
ये
दोनों मिला के
206.
हाँ, दोनों मिला के.
आपको कोई क्या कोई ऑर्डर था कि एनर्जी चार्जेस नहीं रियलाइज करना है? This is if it includes energy charges also, where is the backup bill? If this figure includes energy charges also, where are the backup bills? आपके पास सारे bills हैं?
हाँ
इससे पहले
पहला बिल दिखाइए जिसमें एरियर है. The first bill which carries some arrear.
2008 से पहले
2006 का है ना ये?
दिखाइए. उसके पहले कोई एरियर नहीं था.
2006
I want to see the first bill which shows some arrear, maybe one rupee.
मतलब 2006
2006
का
का जीरो एरियर है.
Zero.
तो 2006 के बाद के सारे बिल्स होने चाहिए ना.
हाँ बिल्कुल
है।
हाँ, कहाँ है? एरियर पहला, सबसे पहला एरियर कहाँ पर है, किस बिल में?
जून 2006 में है 62,532
एरियर 2006 में.
6
उसके पहले का बिल
उससे पहले तो एरिया में 0 दिखा रहा
एरियर में जीरो दिखा रहा है. तो ये 62,000 का एरियर कहाँ से आया?
ये 5/2006 में मैम उसको चार्ज किए थे 52 लाख.
52 lakhs. Then
इसके बाद जून 2006 में वो पेमेंट किया 44 लाख.
इसके अगेंस्ट में paid 44 lakhs. What was the differential?
ये 62 दिया है.
62
52 minus 42, 64,000 होता है. 52 lakhs minus 40. How much is the arrear? How much did he pay? You just give the exact figure. At least I can see through. I can see through one thing, Mr. Yadav. Mr. Yadav, please appreciate. I can see through at least one thing. कि in spite of the fact that your officer has come for only for this case, you are not able to reconcile the figures. तो किसी चार्टर्ड अकाउंटेंट के पास भेज देते हैं रिकंसिलिएशन के लिए. This is not my job to reconcile the figures. If you are not able to do it, you choose the chartered accountant of your choice. We will send for reconciliation and you restore the electricity line. And if there is any differential, they'll pay it. We will not keep the matter pending like this. You can't have it in this manner. You choose chartered accountant of your choice. We will not go by the chartered accountant suggested by the petitioner. नहीं होगा आपसे, नहीं होगा. इतना टाइम नहीं है हम लोग के पास. ठीक है कि जो चीज आपको नहीं समझ में आया वो हम आपसे पूछ के समझें. राइट? You are not, firstly, your affidavits are not clear. Right? Whatever I am asking you, you are looking at your records and saying which is not there before you. Right? Your first bill which you have annexed, in spite of repeated orders, also shows an arrear of rupees 2 crore, which is totally unexplained so far. Right? Therefore, these bills certainly require some reconciliation with respect to your dues with DPS and with respect to their dues with interest payment. And we are going to appoint a chartered accountant. Either you tell us the chartered accountant of your choice, or I will do it in my own. It is absolute. You know so many chartered accountants in Ranchi. You choose.
We will reconcile the bill.
No.
And
You see, this
I
writ
will
court.
make a chart, Malad.
This
I will make
writ,
a chart
Mr.
because-
Yadav, this writ court is not for the purposes of reconciliation of bills. This is not my job. I am not an expert, and I do not know how to reconcile. Right? There is a serious dispute regarding reconciliation of your bills. There cannot be any doubt on that.
My
and it requires each bill and then the calculation of DPS and then the amount to be paid, and whatever amount is paid, first the DPS will be deducted and then it will go to the, those are the principles of accounting. We are not experts on
that they
that.
have already done. It is
No.
a matter of reconciliation.
So therefore,
that
therefore,
question-
therefore, the petitioner has got a right to know that how you have reconciled it.
Yes, they have not enclosed the bills.
Need
madam.
not, they will not enclose anything. You are showing an arrear of rupees 7 crore. There are repeated orders that you show it from the records. You file the bills, the supporting bills. You do not comply with that.
That is the mistake.
A huge
They
mistake.
should have brought on
Therefore,
record the
you
bills,
just
madam.
tell us which chartered accountant should I
Madam,
refer this?
Chartered accountant may not be appointed. madam.
Who
We
will be
produce-
appointed?
We will produce.
No, no, no. We are, Mr.
will
Yadav,
produce
we will not be
reconciled
able
bill.
to. We will not be
My
able
lord,
to
may I-
iron out the
may-
differences
my lord,
between the two.
Case, my lord, may I submit, my lord? Case is totally different from what the petitioner is projecting, my lord. If your lordship will allow me to argue.
No, no.
Totally
No,
entirely
no, no.
different.
You see-
They are saying
Just a
they
moment.
are saying that we are entitled to refund. We are saying that the amount has been kept in abeyance only because we can claim in future if we win the case. Now, so far as 2,58,000 is concerned, we have not claimed any amount from them. We have not demanded. It has been in the kept in abeyance. It has not been added in the total arrear figure ballot. It has not been added. And what?
No, in the
and
bill that you have produced,
Yes.
you have added it in the total areas of 7 crores.
No.
What? You just
No,
have a look at
no,
this.
my lord. Kindly come to the final bill, my lord.
No, no, you just come to this.
Yes.
You just come to your first bill, which you have annexed.
First bill, my lord,
No,
kindly come to the final
no,
bill, my lord.
first we'll come to the final bill later.
First bill also.
No, just a moment.
Which bill, you lordship?
This you were referring to, page number 11.
11.
Yes.
In this case,
You have
one-
calculated this 7892.
7892.
Yes. And this amount you have reduced 1605.
Yes.
This is on which account?
This is on account of KB.
Which period?
पीरियड कब से है? 4 से 2004 से 8 तक का पीरियड है, जिसको हमने
042.
इसमें माइनस कर दिया। 78,000 का इसका डिमांड बच गया। उसके बाद ये फिर पेमेंट भी किए हैं। ये कितना पेमेंट किए? उसके अगेंस्ट में मुझे ये 26 लाख पेमेंट किए हैं। नेक्स्ट पेज में देखा जाए, एज अगेंस्ट द डिमांड ऑफ 78 लाख दे हैड मेड पेमेंट ऑफ ओनली 26 लाख। और इसमें भी दिखा रहा है कैप्टन अवेंस 1 करोड़ 60 लाख, और इनका फिर जो है ये आउटस्टैंडिंग फिर से आ गया 84 लाख नेक्स्ट पेज में। उसके बाद देखा जाए हुजूर, ये जो है उसके बाद ये फिर हमने उसको इफेक्ट दिया 2008 to 2008।
This figure of Captain Abeyance
Yes.
of 2 crore 67 lakhs.
2 crore।
Yes, 2 crore. 2 crore 67,000.
Yes।
An extra one, page 11.
हाँ।
This Captain Abeyance is Captain Abeyance on account of
KBA।
on account
No,
of
no। Captain Aways of 1 crore 60 lakh।
no, this 2. What is this figure about?
Crore 6 lakh is the area which they have not paid
Then
prior
why
to this.
why have you not included it in the demand?
It is included in the demand।
You just see.
It is included
Just
in the
a
demand।
moment.
तभी
You-
तो आया है।
एक second. You just see page number 11.
Yes, ma'am.
40599.
Yes, my lord, it has been added, my lord।
Just a moment.
Yes,
Just come.
yes। ये
First
देखा
figure
जाए,
is 40.
20067।
No, उसके ऊपर आइए 4059958. फिगर
हाँ।
मिला?
हाँ,
ठीक है?
मिल गया मुझे।
मिल गया?
हाँ, उसके नीचे
उसके नीचे
20067 889 ये भी मिल गया मुझे।
200.
6788889
ठीक है?
मिल गया।
ठीक
और
है? उसके
है
बाद
मुझे
आपने उसको ऐड करके
ऐड
239
करके
कर दिया.
239 ये कर दिया मुझे।
ठीक है?
उसके बाद ये रिबेट वगैरह है कुछ,
Rebate
टोटल
है।
आया 239 आया।
ठीक है?
टू
ये जो 2006 का फिगर है, this is on account of KVA charges.
not KVA, it includes KVA as well as energy charge, and this is the
Yeah,
area
how-
which they are
No.
carrying forward।
This is what we want to know.
Yes,
that this figure of 2 crores 67,889,
Yes.
what is the backup of this bill? If it also includes KVA charges could not have been included. Because for the purposes of KVA charges, they were supposed to get adjustment. How KVA charges will become a component of this area?
बिल में रहता है केवी
बिल में KVA आपने जो चार्ज किया, you were supposed to revise and adjust the
Yes.
KVA charges.
Yes.
Then
That your lordship has got my point, madam. Now this is the area to ये जितना भी बोला है मुझे ये कितना है करोड़ में है ना हाँ ये जो केवीए का जो इंक्लूड होते आ रहा था मुझे तो हमको इसको बेनिफिट देना था सिर्फ केवीए का not towards energy charge. So this was revised and recalculated from 2004 to 2008. That figure comes 1 crore 60 lakhs. That figure comes 1 crore 60 lakhs, which we have reduced from the actual demand. And thereafter, the figure of 78 lakhs is the residue amount. It is not that the 1 crore 60 lakh it also includes the energy charge. We have calculated it separately and have given effect to this.
I want to know from you,
Yes.
this figure of 2 crore 67, what is the breakup of this figure?
हाँ वो ब्रेकअप हम वॉल्यूमिनस हो सकता है हम नहीं लाए
Voluminous
हैं
कैसे हो सकता है? It is so
इसीलिए
simple.
इसी
You have a bill of 0 arrear. You start from that. You have all the bills, subsequent bills. It is such a simple thing.
एक मिनट वो हाँ क्लियर कर 2006 में बोल रहे हैं जीरो है और हमको इफेक्ट देना है इसको 2004 से 1/4/2004 से हमको इसको इफेक्ट देना है तो हम 1/4/2004 में जो हमारा जो 100% केवीए चार्ज जो किए हैं उसको हमको इफेक्ट देना है एक्चुअल एनर्जी चार्ज पे तो उसका हमने इफेक्ट देना शुरू किया हुजूर अप्रैल से 2004 से लेकर और ये हम इफेक्ट दे रहे हैं 2008 में तो वो अकॉर्डिंगली वो फिगर वाला हमने हमको करना होगा यस
what all effect has to be given
यस
and what all calculation is to be done has not yet been done by you. No chart as such is there, right? No explanation is there on the affidavit. What is the harm in getting this particular amount reconciled through a chartered accountant?
My lord, they have kindly appreciate, my lord. They have received these bills in 2008 and they have been receiving till 2020. They are now challenging the revised and final bill and 2008 bill in 2020, my lord. Now what prevented if they were agreed that they have not got the refund or we are not following the order of the my lord ombudsman, then they could have raised their grievance before any forum, either before High Court or any other forum, my lord.
See, this writ petition has remained pending for years together.
My lord, this writ petition is of my lord perhaps is 2020, my lord.
Yes.
Ah.
Pleadings are all complete, everything is on
2020,
done, both the
20.
cases are tagged together.
2020 का है 20 का है और
हाँ.
20 के बाद 2 साल सुनवाई नहीं हुआ लगता है अभी 22 से 23 से सुनवाई शुरू हुआ है 2-3 बार हुजूर ने ऑर्डर किया है एंड इनफैक्ट they were supposed to produce the bills because if they want to make out a case, my lord, they should have produced the bill, my lord. But anyway, if your lordship is directing, we will reconcile. They have already reconciled, therefore given effect. Otherwise, it is not in
This
error,
is
my
so
lord.
far as the arrear is concerned. What about their claim for refund arising out of other orders?
Yes, उस पे भी आ जाते हैं उस पे भी आ जाते हैं. Now kindly see the second order of the USNF, my lord, that there was a dispute that they have given a request for reduction of their contract demand
Okay,
from 5100 to 2900.
that's right.
Now the forum held that they are entitled for reduction from the date when their reduction was sanctioned. That is the date.
That's right.
Now from that date, because that order was passed कब हुआ है? in 2016.
Okay.
Now we have to give effect from the date of sanction. Sanction कब हुआ है? 2007 वो उसका हमने इफेक्ट दिया हुजूर, वो भी हमने लगाया है. 2 बिल हम दिखा देते हैं हुजूर. योर लॉर्डशिप विल गेट कन्विंस्ड लगा. ये देखा जाए, ये देखा जाए, पेज 29 देखा जाए.
Yes, 29.
यस मैम. इसमें देखा जाए हुजूर, ये 6 करोड़ का इनका बकाया है हुजूर. And this is on account of KVA as well as energy. अब ये 6 करोड़ जो हुजूर ये इनका बकाया था, हमने नेक्स्ट पेज देखा जाए हुजूर, पेज 30. पेज 30 में हुजूर ये इनका 3,50,96,000, इसका हमने डिटेल ये दिया हुआ पेज 31 में. पेज 31 देखा जाए, ये एज पर रिवाइज एज पर व्यूएशन ऑफ ऑर्डर डेटेड 12/11/2016 इन केस नंबर so and so ड्यूली अप्रूव्ड बाय so and so डेटेड इतना 2,58,00,000. सो 2,58,00,000 का ये इफेक्ट आया व्हाइल ऑन अकाउंट ऑफ रिडक्शन ऑफ कॉन्ट्रैक्ट डिमांड में. और ये हमने वो 6 करोड़ में से वो जो बिल था जो प्रीवियस, क्योंकि ये जो बिल था जो ये है 20 दिसंबर 2016 का, और इसको इफेक्ट दिया है हमने ये 5 दिसंबर 16 का ही है दोनों बिल. 5 दिसंबर 16 को ही 6 करोड़ का बिल था, और ये देखा जाए जो ये जो बिल उसी दिन कैलकुलेट किया गया 5 करोड़ 16 का, उसको हमने रिवाइज किया है 6 करोड़ को इफेक्ट देने के लिए, वो 3,50,00,000 है. नाउ द डिफरेंस बिटवीन 3,50,00,000 एंड 6 करोड़ दैट कम्स टू 2,58,00,000. Now 2,58,00,000 is the amount which the board is not entitled to get, because that is towards the reduction of load calculated by load, and this amount is shown as kept in abeyance. I have stated in my submission, kept in abeyance only because the recommendation was made by the circle malord, and it was pointed out by GM that why the appeal was not preferred, therefore he has issued show cause notice, and therefore that amount was kept in abeyance. So because of non-approval of deleting that amount only, because of that only it is shown as kept in abeyance even in the final bill. So there is no difficulty in removing that 2,58,00,000. 2,58,00,000 is nothing, but it is the actual effect of reduction of load that has been given in the final bill or in the bill dated December 2016. Because we have complied the order, and we are not claiming that amount, nor we are charging any DPS over that amount since 2016 in compliance of the order of BUSNF malord. So this is 258 malord. 258 we cannot claim amount because we have not preferred any appeal. So that amount gets deleted, and even if it is written in kept in abeyance, we are not recovering or we are not charging any DPS over that amount.
Why will you keep it in abeyance?
Yes, for that only I have explained, madam.
Why will you keep that amount in abeyance?
That should not be. I have
so that amount should be deleted, and they should get back that amount.
I have said so, madam. Kindly appreciate, madam. I have said so. ये पेज 6 देखा जाए, पेज 6 में हमने बोला है, पेज 6 में पैरा 3 में बोला है, it is submitted that the litigants in terms of debtor has requested to take decision on the amount of itna which is reflecting in each monthly energy bill as kept in abeyance, as the respondent did not prefer appeal against ombudsman order, but the competent authority being general manager Jamshedpur, instead of taking any decision with respect to deletion of the said amount, has directed so and so to submit the reason as to why appeal. So for that,
so according to you,
yes, for that reason,
just a moment, according to you, this amount of rupees 258,42,428, no, this
258.
How much is the adjustable amount according to you?
258.
258,42,428 is an amount which was refundable to the petitioner.
Not refundable.
Then what?
That has been adjusted from 6 crore.
No, originally it was refundable.
Originally.
But you say that since there was dues, it was to be adjusted.
Yes, adjusted also.
Right? And according to you, when did you adjust this amount?
No.
What is the date of adjustment?
तो ये 12 नहीं 5/5/12/16
And after adjusting this amount, so this particular amount which you have shown in your supplementary affidavit in the writ petition, page number 120,
हाँ of the REIT one.
yes,
Yeah.
you want to say that this figure of rupees 258.42,428 has already been adjusted.
Yes.
And then this one, difference of rupees 321.29.
This has also been adjusted. Already been adjusted.
No,
Therefore,
this-
it has been kept in abeyance.
This amount has been adjusted.
Yes.
You want to say that the matter which is pending before the Honorable Supreme Court,
Ma'am.
the order impugned has already been given
And-
effect to.
Yes, ma'am. Already
Why?
been given effect to matter, but we are showing as kept in abeyance because the matter is live before Supreme Court. In case we win the case, then we will be entitled. Otherwise, if we delete this kept in abeyance, they will say there was no demand in
Okay.
existence.
Let us see what
Then-
is let us see what is the situation in the other writ petition, because it is flowing out of the other writ petition only.
No, it is flowing from this KVA malord. जो KVA का जो इफेक्ट देना था उसके लिए है पिटीशन. जो ऑर्डर ऑफ ombudsman is under challenge.
That's right.
Yes.
So this is also arising out of KVA only. The matter which is pending before the Honorable Supreme Court
Yes,
is arising
exactly.
out of
Same
KVA
matter.
only,
Same
same matter.
Same matter. Same
So
matter.
let us see.
Ma'am.
Where do you say that this amount has not been paid by them? They say that this amount has been paid by them. You come to annexure R/4 in the second record. Filed by the respondent, it is your bill.
R by no, ma'am, it is bill of Union Enterprises.
No, page number 26.
Yes, ma'am.
in the counter affidavit,
Union
Jharkhand
Enterprise.
Bijli Vitran Nigam
उसके
Limited.
नीचे देखा जाए कंज्यूमर का नाम यूनियन इंटरप्राइजेस.
Union Enterprises.
Yes.
Okay, it is not there. What is the name of their
KYS. in fact.
KYS? Para number 8, they have stated that Jharkhand Bijli Vitran Nigam Limited issued a provisional bill in the light of order of GM cum Chief Engineer.
Union Enterprise.
Union Enterprises. We are not concerned with Union Enterprises. They have stated nothing about their own bill. Supplementary affidavit was also filed. What was the statement? ये उल्टा लगा हुआ है इसमें. Okay, now this amount of rupees 321,29,531 according to you, firstly this figure of rupees 258 has already been adjusted.
Yes.
This is what is according to you. Okay, and this 321,29,513
That also stands registered.
also stands adjusted. So this particular amount, which the two amount which they project that they are entitled to refund of this amount, they are actually not entitled to any refund,
Not.
and this is the net amount payable by them.
Yes. And what we are not entitled, even if in the case 258 lakh because we have not challenged.
This 258.
258 वाला जो है वो
You
final हो
say
गया.
that it has become final and you have given the effect to it.
Yes.
This is your case.
Yes.
So far as these two figures are
हाँ.
concerned.
और जो लास्ट जो रिवाइज बिल जो हमने लिया है वो उसमें हमने अमाउंट जो 39 लाख और 1 करोड़ 47 लाख जो है वो हमने रिड्यूस किया है फ्रॉम द एक्चुअल डिमांड बिकॉज वी कंटिन्यू टू चार्ज डीपीएस ओवर दोज अमाउंट नॉन
So
पेमेंट
you
ऑफ
must have adjusted with interest.
यस
You must have adjusted also with interest.
वी हैव एक्सट्रैक्टेड दैट मैंने उसको रिड्यूस हमने देके उसको इफेक्ट कर दिया
इंटरेस्ट के साथ पहले चार्ज किया, उसके बाद इंटरेस्ट डिडक्ट कर दिया. यही किया है ना?
देखो प्रिंसिपल अमाउंट वो दोनों जो प्रिंसिपल अमाउंट है जो इंटरेस्ट पोर्शन है इसमें रखा हुआ है.
इंटरेस्ट
प्रिंसिपल अमाउंट
आपसे बेहतर कौन इनको कैलकुलेशन समझाएगा?
हम
You are master in banking.
हम इतना अभी घुसे नहीं हैं थोड़ा और दो चार
It
बार
requires
इनके साथ बैठेंगे तो
reconciliation.
समझ
I'll pass appropriate order. It certainly requires reconciliation, and your submission that this amount is already adjusted,
Yes.
that will be recorded, and it requires
No, I can
reconciliation.
show from the
You
bills
don't
also.
need to, but this requires reconciliation, whether this amount has been adjusted with interest as per the direction of ombudsman. Date of adjustment. You see, this is very simple. Mr. A has to give Mr. B 100 rupees with interest at the rate of 10%, right? And Mr. B has to give some amount with interest. So the date of adjustment, the date on which the adjustment is carried out, the interest up to that date is to be calculated on both the sides. It cannot be that electricity board will continue to carry interest, their dues will continue to carry interest, and their refund will not carry interest. And you will
Exactly.
adjust it on whatever date you want.
Exactly. That is the reason both the amounts have been kept in abeyance. If I continue to charge, I will have to, if they are
Charge
entitled,
means
if
if they are entitled to refund, and if you say that this amount has been adjusted, there is no question of any interest on that.
Yes, correct. That is my submission. इसीलिए तो kept in abeyance में रखा गया
Mr.
होगा.
Bhaluka, it requires lot of
I'll be highly
reconciliation.
grateful, Manoj. I
We
vote
will
on
not
your
be
lordship.
able to do it,
My lord.
but the mode of reconciliation, I am asking them to
Lordship, please.
give a name of the chartered accountant. They are not willing to.
My lord.
You suggest some name,
We
because
vote
they are
on
not
your
willing to
lordship's
give
suggestion.
any. We are chartered accountants in our legal services authority
My
also.
lord.
There is no problem.
My
Both
lord.
the parties will sit with their calculation
My lord.
and bills and reconciliation. That will be done.
My lord.
And then this particular case, your case, which you have filed,
Lordship, please.
will certainly boil down to a fresh cause of action.
I appreciate, Manoj. I am completely vote on to your lordship's.
Because
The thing is, at the end
there are figures we do not match with each other.
That is exactly what in fact, that is the reason your lordship had repeatedly asked him to file a detailed affidavit. Now, today, what is come on the written submissions clearly is not part of the pleadings, one. Number two, I also don't have the occasion of really seeing and seeking instructions. And I'll be unfair on my part before your lordship if I say that the reconciliation should be done.
No, I am
before your
not
lordship.
asking you, nor I am asking them.
My
I
lord.
will send it for
I'll be
reconciliation.
grateful.
Since both, I would not like the name to be suggested by you. It
My
will
lord.
not be proper also. I'm asking them time and again, but
My
they
lord.
will not suggest any name.
Lordship.
Then I'll have to choose somebody myself. But this has to go for reconciliation. It can't go on like this. No.
They have already done a lot of.
You must have done lot of things at home. You don't bother about it.
Therefore,
You see,
because-
whenever a demand is raised, the consumer has got a right to know the breakup. You are not able to satisfy this court, then you sit,
Is it possible, my lord, that each and every month they will not serve the bill, my lord?
it is quite possible. We do not
No.
know. We have a lot of
They have
experience
not
with
said so that
electricity
they are not
department.
getting the bill. They have been continuously. I have seen the records. They have got the bills of each and every month.
Must have.
Every month bill is there.
You
my lord.
both of you sit down. I
Yeah.
will appoint somebody for reconciliation. That is required to be done. We can't do anything.
Lordship.
And we have honestly complied the order of the honorable court.
So this I will record that as per your instruction, this amount has already been adjusted in
Yes,
the
given
bills.
effect, my lord, as per the direction of the ombudsman.
And what is not to be adjusted is only the amount which is pending before the Honorable Supreme Court. Even that you have adjusted according to you.
Yes, even that we have adjusted.
Everything you have
Ah.
adjusted.
Even that we have adjusted. And
So the
whatever
order,
our
therefore-
demand is of 7 crore, that is the area.
That is
Actually,
the
that is
area
the
after
area.
adjusting that amount.
Yes, my lord. After adjustment of that amount, that is the 7 crore something. That is the final revised bill, my lord. That is the area, because they have stopped making payment, my lord. We had no option then to make a disconnection, my lord.
Done?
Yes.
What will happen to your other case? Can we dispose
There-
it off
there-
by saying that it will be subject to whatever happens before
It
the
can be,
Honorable
my lord,
Supreme
because
Court?
I have annexed the order of the division
Will
bench
that
also,
be
my lord.
That can be
sufficient?
done. Lordship.
That can be done?
My lord.
Yes, madam. I have annexed the copy of the division bench who has decided this issue, which is pending before Supreme Court.
Okay. There is, first let us take up the second case and then dispose it off by saying that the orders passed by the Honorable Supreme Court, the parties will be governed by
Ma'am.
that. What is the SLP number?
SLP number I have given, madam.
This would be WPC number.
So this is number 1837 of 2008, Malad.
Okay.
SLP civil number 27764.
Just a moment.
Malad, this is the ECL, the latest position we have.
SLP civil 27764 of 2016. You are also a party there? No.
Yes, he has been appearing, perhaps your name is there.
No, we are talking about the client.
No, this client.
But they will be governed by the same.
They would be, Manoj, eventually it's the same issue.
देखिए WPC number 1837 of 2008. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the same issue is pending before the Honorable Supreme Court in special leave to appeal within bracket C number 27764 of 2016. And he submits that this writ petition can be disposed of by observing that the parties would be governed by the judgments which may be eventually passed by the Honorable Supreme Court. The learned counsel for the respondent has no objection to the prayer made. He is also in agreement with the fact that the issue involved in this writ petition would ultimately be governed by the pronouncement of the Honorable Supreme Court. In view of the aforesaid submission, this court is not inclined to proceed any further in this writ petition, and this writ petition is disposed of by observing that the parties would be governed by the judgment which will be passed by the Honorable Supreme Court in the aforesaid civil appeal. So this goes so far as the other writ petition.
My objection was with respect to maintainability matter, because they are disputing about the correctness of the bill matter for which they are put
No, they are not disputing about the correctness of the bill. Now you say that it has already been given effect to, so it only requires reconciliation. That's it, isn't it?
That can be done with forum.
That will be done, and I will dispose it of also.
विद्युत का forum में भेज दिया जाएगा, वहाँ पे decide हो जाएगा.
वहाँ पे कुछ नहीं होगा decide.
मतलब it is functional matter है जमशेदपुर में, वहाँ भेज सकते हैं. इसको पहले भेजते हैं आपके जालसा में. एक बार को सारा कुछ आप रिकंसिलिएशन कर लीजिए. आपको क्या लगता है? नहीं समझ पाएंगे. हम कहाँ जानते हैं? हमको तो नहीं पता. नहीं, first we will send it to Jalsa. You see, it requires, you see, as per law also, there has to be some kind of mediation before litigation, isn't it? As per commercial law now. So we will send it to Jalsa, such that the parties sit together and know each other's point of view. And once that is done, if there is any further dispute, it will be certainly open to the petitioner to agitate the matter before the. And I will just record that so far as your final bill is concerned, you say that this amount has already been given effect to, and there is no surviving demand in connection with these two amounts. These two.
I will simply say that that the order of this court, which is subject matter of Honorable Supreme Court, the order has already been given effect. It is only being shown for the purposes of record and nothing more.
For
Yeah,
claiming
is that
in
correct?
future, for claim.
Yes, for
To be
claiming
made
in
in future.
future. But so far as the other
And one
part
more
is,
thing I have not
just
disclosed, my lord.
just a
One more
moment,
thing I
just
have
a
not
moment.
disclosed, my lord. We
There
have
is-
also filed a certificate case against him.
Must have.
Yes, ma'am. That is pending.
We do not. There is one more thing. So far as this 258 is concerned, it is useless because it has been given
Yes,
effect.
ma'am. It can be recorded.
It can be recorded.
This
Yes.
is what his submission is.
Go on down हटाने से कोई दिक्कत नहीं.
उसमें तो कोई दिक्कत नहीं.
नहीं.
certificate case, the figure is now completely different. It is something 6 crores 31 lakhs.
After the
Clearly
adjustment of
reconciliation-
security
Everything will be
amount,
taken
security
care of.
amount को adjust करने के बाद हमने certificate case किया है, तो that
That's
is
why-
why they
ये
are
किया है
pointing.
कोई बात नहीं,
Yes,
कुछ नहीं।
different
उससे
figure is there.
कोई उससे कुछ फर्क नहीं पड़ता है. Reconciliation is absolutely necessary. I feel that reconciliation is necessary.
We vote on.
देखिए, this writ petition has WPC number 3887 of 2020. This writ petition has been
My
filed.
lord, before starting, your lordship is already observing regarding two figures, my lord. So far as this demand of 7 crore arrears, my lord.
I will take care of everything.
My lord.
I will take care of everything. The question of any restoration of electricity will arise only when,
Yes.
because the electricity stands disconnected. After reconciliation, whatever figure is arrived at between the parties, that can certainly be drawn and shown, or you will have at least an occasion to find out whether this figure is properly reconciled or not. You will have an opportunity to see each other's document in connection with this. This is what I am actually observing. Right? The chartered accountant will record each one of your submissions. With regard to the bills, you can produce the chart also before him. Right? That can be done.
My lord, to my opinion,
For the purposes of reconciliation, a
whatever
chartered
your lordship
accountant.
is observing, that is correct, my lord. But I have seen the records, my lord. It appears that they have purposely raised the dispute, my lord, for getting all these things done.
So you want to get rid of that
Because and this is coming in the
The
way of
pseudo
recovery.
dispute.
This is coming in the way of recovery. That is the whole issue.
is there any stay?
Well,
Is there any stay?
there is no stay, my lord.
Then-
But the High Court is hearing the matter. Certificate court will certainly not proceed, my lord.
I don't know any such law. The certificate proceeding is not under challenge in this case.
That has not been challenged.
Okay, WPC number 3887 of 2020. This writ petition has been filed for the following relief. Appearance सबका लिखा है. The foundational background of the case is that the petitioner, having consumer number 7028 HJAP 144 category HT, was having contract demand of 2900 kVA. The date of connection being 1/4/1998. The petitioner was granted electricity connection for 2700 kVA for running the induction furnace. Later on, from March 2006, and after sanction of petitioner's license, the petitioner was availing. The petitioner was granted 5100 kVA under category tariff number 2003, effective from 1/1/2004. And the petitioner was billed on the basis of actual consumption of electricity recorded in the meter and not on the basis of 100% and the onwards, and the petitioner was required to be billed on the basis of actual consumption of electricity recorded in the meter and not on the basis of 100% contract demand. But the petitioner, with effect from 1/1/2004, was billed for 100% of the contract demand. In such circumstances, the petitioner filed a case before the forum constituted under the Electricity Act 2003, which was registered as case number 18 of 2007, and by a judgment dated 25/9/2007, it was held that the respondents are not entitled to bill the petitioner on the basis of 100% contract demand as KVA charges. And consequently, the bills impugned for the period from 1/1/2004 onwards, in which KVA charges was raised on the basis of 100% contract demand, were quashed, and the respondents were directed to issue the monthly energy bills on the basis of actual KVA recorded in the meter. And the respondents were further directed to adjust the excess money realized from the petitioner in the subsequent bills with interest as per the supply code regulation. It was indicated in the judgment that the judgment would be subject to the decision passed by High Court in WPC number 1687 of 2007. What is 1687? The connected writ petition. What is 1687?
Connected is 1837.
जो 1687 देखिए तो of 2007.
दूसरा देखो
वो किसका writ है? 1687 is connected writ petition. No. देखिए जरा 1687 of 2007.
2007.
Dismiss.
Malad, this is regarding TMT metals, Malad.
Oh, anyways.
TMT metals, Malad, what has happened, Malad? In TMT metals and another matter, Malad, order was passed based on the Lakshmi business, Malad, and
Anyways, let's forget.
content
Because
was
we are
fine,
not
Malad.
concerned
We
with
are
it.
not concerned,
Okay.
Malad, because in that matter we
That's
have
it.
given effect.
No problem. Thereafter, the judgment of the forum was challenged in appeal before the electricity ombudsman, and it was registered as case number EOT/16/2007, and which was dismissed by judgment dated 28/2/2008. And the which in turn has been challenged in this writ petition. And the judgment of the ombudsman was challenged in WPC number 1837 of 2008. The connected matter arising out of the same issue is pending before the Honorable Supreme Court in SLP number 27764 of 2016, and consequently the connected writ petition being WPC number 1837 of 2008 has been disposed of by this court. By observing that the said case will be governed by the judgment to be passed by the Honorable Supreme Court in 846 Civil Appeal. The grievance of the petitioner which survives in the present case is that the respondent issued a bill dated 9/8/2008 for the month of July 2008 in which an amount of rupees 1,60,51,800 was kept in abeyance. And it was not clear to the petitioner as to why the said amount was kept in abeyance, and it was the understanding of the petitioner that this amount was refundable to the petitioner as per the judgment of the forum, and against which the appeal was dismissed by the ombudsman. It was further the case of the petitioner in this writ petition that the petitioner was served with another bill for the bill dated 9/11/2020, wherein an amount of rupees 7,82,83,328 has been shown as arrears, but no detail was furnished in connection with such arrear, and an amount of rupees 4,56,64,812 was shown as amount kept in abeyance, for which also there was no detail furnished. Another bill was, the petitioner was also served with a letter dated 16/6/2021, wherein, which was a disconnection notice, and an amount of rupees 8,29,60071 was shown to be in arrears, excluding, and the petitioner was to pay the amount excluding rupees 4,56,64,812, which was said to be kept in abeyance, and on account of non-payment of such bill, the electricity line of the petitioner was disconnected in the month of July 2021. The grievance of the petitioner still was that there was neither any breakup in connection with the dues nor any breakup in connection with the amount which was shown in kept in abeyance. Another letter dated 26/4/2023 was issued revising the provisional bill amounting to rupees 4,7,49,27,967, enclosing a bill therewith dated 26/4/2023, which was revised provisional bill, and in the said bill it was a certain amount was kept in abeyance. The said bill indicated the provisional final bill already served, less excess unit charged for the period June 2011 to August 2011, less of difference of CD and actual KVA with DPS for the period from 8/2009 to 4/2010, and had the following remarks. And certain payments were again shown to be kept in abeyance. So far as the provisional final bill of rupees 1,21,06,965, इसको जो है ना पूरा extract कर लीजिए, वो emboss कर दीजिएगा इसको, है ना? So far as the provisional final bill of rupees 1,21,06,965 is concerned, the same was said to be pending in LPA number 350 of 2015, and as reported, the said LPA is still pending before this court, and the parties have nothing to say so far as this provisional final bill is concerned. And the two amounts were kept in abeyance by stating as follows: A and B को quote करना है इसमें. This court finds that on 13/10/2023, the following order was passed. Quote करना है. Where the grievance of the petitioner is reflected in the order dated 13/10/2023, and the petitioner claimed that the petitioner was clueless in connection with the breakup of the huge amount which was shown as arrears, and also as to why the claim of refund of the petitioner arising out of another case. What is the case number of that? The other one? दूसरा का केस नंबर कौन सा? दूसरा वाला जो था, जो फाइनल हो गया.
1837 of 2000.
नहीं, the other
One, the 2.58 crores.
2.5.
My lords. Because that is at page 101.
case number.
This is case number 03 of 2015 by the forum.
03 of 2015, wherein the petitioner was entitled to refund, had attained finality, but as to why the said refund was also kept in abeyance. Another order was passed on, pursuant to the said order, a supplementary counter affidavit was filed, but that was not satisfactory, and consequently another order dated 1/12/2023 has been passed, which is quoted as under. Pursuant thereto, a supplementary counter affidavit has been filed, and a written submissions has also been filed on affidavit, annexing certain bills and breakup. इनका नाम बताइए. Mr. So and so, give it in writing with designation, has appeared before this court with the records and the learned counsel appearing on behalf of the respondent, and has been assisting the learned counsel appearing on behalf of the respondent to explain the breakup and details of the bills. During the course of argument, it has been submitted by the learned counsel for the respondents that the amount of rupees 3,21,29,513 which has been shown to be under the heading kept in abeyance in the final bill dated 26/4/2023 has already been adjusted in the dues of the petitioner, and the said amount has only been shown to be kept in abeyance so that the respondent can claim this amount subject to the result of the judgment to be passed by the Honorable Supreme Court. Right? So far as the other amount amounting to rupees 2,58,42,428, which relates to reduction of contract demand from 5100 kVA to 2700 kVA is concerned, the Learned Counsel submits that this particular amount has already been given adjustment to the petitioner, and no dispute in this particular in connection with this amount is pending. You have given the adjustment with interest. The Learned Counsel on instruction from the officer of the respondent submits that these amounts have been adjusted with interest, and the demand is only on account of the pending bills. However, during the course of argument, the huge arrears which has been shown against the petitioner could not be explained as neither any chart.
हमने 3 बिल लगाया है ये शो करने के लिए एक
I could not understand. You see, my understanding could be poor.
नहीं हम वो नहीं बोल रहे हम ये बोल रहे हैं कि कुछ नहीं लगाए वो मैंने उसमें नहीं लगाया था लेकिन इसमें लगाया 2015 का 2020 का और 2022 का टू शो कि एरिया शुरू से ही चला आ रहा है देखिए ना 6 करोड़ का है
This court finds that certain bills have been annexed along with the written submissions filed by the petitioner,
पेज 33 देखिए
and the earliest bill which has been annexed along with the written submissions is dated.
पेज 33
Just a
dated
moment.
6 April 2015
No, we will just refer to something else.
ये 10 का है ये सबसे लेटेस्ट है पेज 34 पर
Just
उल्टा लगा दिया है
is the earliest bill which has been annexed by the respondents along with the written notes of argument is dated
4/11/2010
just a moment, is dated 9/9/2008, which also shows an arrear of rupees 2,00,67,889.
हाँ बराबर
Right?
पेज 34 देखिए
And the other bills which have been annexed, which relate to the period 2010,
इसमें भी है
and then
and then 6 April 2015
6th April 2015
and
also
then
shows arrears against the petitioner.
area इसमें बराबर
However, this court is of the considered view that these bills are not sufficient to iron out the grievance of the petitioner regarding the breakup of the bills. The petitioner against whom huge bill has been raised is not only entitled for breakup of each bill but is also entitled for calculation with respect to the delayed payment surcharge raised and realized by the respondents, and also the calculation with regard to the interest which the petitioner is entitled by virtue of any claim of refund. This court is of the view that the matter regarding the bills and the claim and counterclaim of the parties is required to be reconciled, and such reconciliation is possible only when both the parties sit together in the presence of one expert, which could be a chartered accountant. Jharkhand Legal Services Authority has a number of has chartered accountant. This court is aware that Jharkhand State Legal Services Authority has chartered accountants in their panel who have been acting as mediator, and accordingly this court directs the petitioner as well as the respondent to appear before Jharkhand State Legal Services Authority so that a chartered accountant can be appointed only for the purposes of reconciliation of the bills of both the parties. Both the parties shall produce the details regarding the bills as well as their respective calculations before the chartered accountant, and upon exchange of such document, if anything admissible is found payable by the petitioner shall take steps in accordance with, the parties shall take steps in accordance with law. And if any dispute still subsists, then it will be open to the parties to approach the Vidyut Forum, which is a forum constituted under the provisions of Electricity Act 2003 for redressal of their claims. डेट फिक्स कर बताइए कौन सा डेट आपको कन्वीनियंट होगा? हाँ, आपको चार्ट बनाना होगा पहले. 15-20 दिन का टाइम आपको भी दे दे. 15-20 दिन का टाइम. With the consent of the learned counsel for the parties, the parties shall appear before the Jharkhand State Legal Services Authority on 20th March. ज़्यादा कम हो रहा टाइम, जस्ट नहीं, इनका 31st निकल जाने दीजिए, लोग परेशान होंगे 31st को. On 8th of April, is that okay? 8th of April, upon their appearance, the Secretary Jharkhand Legal Services Authority shall do the needful and appoint a chartered accountant for the purposes of reconciliation of the bills of the petition. That's it.
For the restoration of electricity, considering that the present situation is such that whatever affidavits and bills have come forth, there is clearly
not now. Please hold on for some time.
Lordship.
It will be reconciled. We know that you have suffered for quite some time, but not now, because they have tried to make out a case that whatever claims you were claiming as refund has already been adjusted against your dues. This is something which is very, very important.
I completely vote on Malas, but the consideration Malas today in the written submissions, finally this thing, something seems to have, but Malas, what prejudice would be caused with them? Anyway, in future, whatever bills come, I will be paying, subject to what your Lordship has sent for reconciliation. Once reconciliation is done, if there is something which is actually kind of a settlement, I would be paying, or I'll approaching my appropriate forums. They always have a right to then immediately issue discretion notice again.
I'm not inclined to restore the electricity right now.
Malas.
But I will just say that needful be done by the chartered accountant within a period of 15 days from the date of appearance of the parties.
I'll be grateful. At least the time period would be helpful.
That's it.
Lordship.
This petition is accordingly disposed of.
Highly grateful.
Not patience with this kind of a record. There is one transfer matter. Yes, Mr. Anil Kumar is there. He is left. Departmental proceeding.
But may I submit my written notice? Since it is not being taken up today.
I know. I'm sorry I couldn't do it.
Happens for us. Nobody can help it. Along with rules and
Yes, what do you say? Can we do it tomorrow?
can it be on Monday? Because tomorrow I have some fixed schedule in September 2 months. Therefore I am paying only on Monday.
Monday? Monday को हम लोग कुछ रखें हैं सवालों में? कल मंडे को रखें सवाल कौन सी
देखिए
कौन सा केस है मंडे को? अच्छा ठीक है इसको रखते हैं मंडे को WPS number 3734 of 2024 sorry 2023 due to paucity of time this case could not be taken up for further hearing today post this case on Monday as first case at
serial number मतलब serial number 54
क्या
meeting has been completed
उठते समय बोलते हैं हम तो सबका डेट फिक्स कर देते हैं और बहुत अर्जेंसी होता है तो नेक्स्ट डे सप्लीमेंट्री में ला देते हैं क्या अर्जेंसी है अब रिटायर ही हो गया तो क्या अर्जेंसी
ACP और MECP के कैलकुलेशन बाकी था प्लीडिंग कंप्लीट हो गया है रिजल्ट भी दे दी खाली एक डेट एप्लीकेशन
क्या बोलते हैं अदर साइड क्या बोलते हैं काउंटर में क्या बोलते हैं दे एडमिट योर क्लेम
हां कुछ एडमिट किया है
क्या एडमिट किया डिपार्टमेंटल प्रोसीडिंग डिपार्टमेंटल एग्जाम पास किए हैं
पास किए
थे आप फिर क्या प्रॉब्लम
प्रोसीडिंग पेंडिंग
तो प्रोसीडिंग पेंडिंग होगा तो आपको मिलेगा
मतलब एनी डेट मतलब
डेट तो आई विल गिव बट आई एम जस्ट आस्किंग
No, if you also see the scheme of MSCP matter, let's say that you are
आप उनको क्यों परेशान करें आप हैं उस केस में हाँ
just
हाँ बोलिए
right now I am not seeing this counter
यू गेट रेडी एंड देन मेंशन हम तो जब जितना लोग मेंशन करते हैं उसी में अपना माइंड मेकअप करते हैं आप मेरे बात का जवाब ही नहीं दे रहे इसको ना लंबा डेट मत दीजिएगा नेक्स्ट वीक का डेट में रहने दीजिएगा ठीक है सोच समझ के मेंशन करिए अदर साइड को लेके आइए और एक दिन पहले स्लिप दे दीजिए